Hello everyone, welcome to the first lecture of criminal law. In this lecture, we will be discussing the general principles of criminal law, mens rea and the statutory exclusion of mens rea, attempt as well as preparation of an offence, and punishment, and specifically capital punishment. Please remember that when it comes to criminal law, knowing the theory is not as much important as knowing the exact language of the section, the key elements of the section, and the more important case laws and how they have basically interpreted certain portions of the section. Otherwise, the sections are very clear. So the provisions and the case laws are more important. There will be certain areas where we will discuss juristic opinions and how the law has developed, especially in England, because a lot of criminal law has developed more from England and then it was taken for the same interpretations were taken to India. We will be looking at all of it in that sense. Okay, I will be specifically explaining which of the cases which I mentioned are landmark cases and otherwise which cases are regular cases. Right? So the first topic is general principles of crime. There are multiple theorists which have tried to give a definition of what constitutes a crime. So Russell, who is the author of Russell on Crime, one of the most important treatises on criminal law, has said this very specific line that to define crime is a task which has not been satisfactorily achieved. Okay, because what is a crime and what is an acceptable situation to society is very difficult to analyze at some times. Some things are very clear for us. For example, murder is a crime, rape is a crime. But let's say something like homosexuality, which was once upon a time it was considered a very criminal offense. Today it has a lot of social acceptability. The Supreme Court has also decriminalized the homosexual intercourse now. So these keep changing according to social norms, right? So another definition is by Blackstone that crime is any violation of public rights and duties to the whole community. Okay, this is to distinguish it from contract. Okay, contract is against private individual, whereas crime is against the whole community. That is why it is also prosecuted whenever there is a crime. It is prosecuted instead of simply tried in a civil court, and simultaneously the prosecution is the state. Okay, so the state acts on behalf of the entire community. The third definition is by Jerome Hall, which says there are multiple characteristics which must be fulfilled for any action to be a crime. Firstly, there should be harm, called the harm principle. It should be prohibited by law. In India, the fundamental rights specify that there can be no criminal penalty imposed except by authority of law. Third, it has to be caused by some human conduct. It cannot be a harm which is caused by any form of natural calamity. You cannot end up blaming anyone. And there should be an intention to commit a crime. Okay, we will come to this portion when we discuss in the coming slides the importance of actus reus and mens rea. But basically, the sense that we get is that any human conduct which is against social interest is a crime. The state has wide powers to define what is social interest, and accordingly, whatever the society as a whole feels is wrong will be considered wrong. For example, in very religiously orthodox countries such as Pakistan, Saudi Arabia, etc., blasphemy is prohibited, that you cannot criticize religion at all because that is against social interest. Whereas in other countries such as Sweden, United States, etc., any form of criticism of religion is not prohibited. It is considered well within the freedom of speech. So it depends upon the social interest and decided by the society. IPC as a whole does not use the word crime. It uses the word offense. So under IPC, whatever is punishable, any act punishable under the Indian Penal Code is an offense. Okay, there is no crime. The word criminal comes multiple times, but crime as a whole is not the issue of IPC. Okay. So these are the three components of a crime. First one is actus reus, which is guilty act. Second is mens rea, which is guilty mind. Rea normally means guilty, okay, culpable. And the third part in many cases is a concomitant circumstance. Okay, sometimes doing an act in itself is not necessarily a crime. There has to be other conditions. Okay, for example, when it comes to the crime of trespass, section 441 did not for this, it needs to be someone else's place. There is a crime called house breaking by night. The time becomes important. If it is before 6 p.m., then it will not be house breaking by night. Okay. Let's say, for example, in the offense of rape under section 375 of the IPC, what is important is the absence of consent. Sexual intercourse in itself is not prohibited under any law. Sexual intercourse with a woman without her consent, okay, is important. So in the offense of rape, intention of the rapist is not necessary. Okay, you may say that I did not intend this or I did not mean it that way. It doesn't matter. If the victim of rape did not consent to sexual intercourse, then it is called rape. So that is the concomitant circumstance is consent. For certain offenses like abduction, the age of the victim, okay, kidnapping a minor, all of these offenses, the age of the victim, the concomitant circumstance, which becomes very important. Okay. Now we come to actus reus. Okay. The guilty act. Without a guilty act, there is no punishment. Okay. You will never, there is nothing called a thought crime which can be punished. This was once upon a time in medieval Europe, this was considered a crime where even if you thought something which the church believed was against social interest, then you could be punished. No longer does any society believe in thought crime. Okay. Actus reus is necessary, that there has to be the act. Now this is not just doing of something, it is the causing of an effect. Okay. It is defined as an effect caused. In fact, Ratan Lal and Dheeraj Lal is one of the most important commentaries on criminal law that you will find. Okay. Define actus reus as the result of human conduct. Alright. For example, in the offense of murder, if death is caused, only then it is murder. Okay, whoever causes death, if you read section 299 and 300 of IPC, you will see it begins with whoever causes death with the intention of causing death. Alright. So, and if death is not caused, then it is not the offense of murder. Even if you shoot someone and the bullet hits the wall and that person is saved, you will at most be punished for attempt to murder. You will not be punished for murder. Okay, even though you had the same intention. So that is the difference. The various definitions under IPC also mention this. Okay, for example, voluntary is section 39. Section 39 of IPC, section 1 clause 33 of BNS. Okay, the Bharatiya Nyaya Sanhita mentions the word voluntary. Okay, now if you read this, and always keep the Bare Act in handy whenever I am explaining. Okay, an effect is caused voluntarily when it is intended or known that it is likely to be caused. Okay, even there the focus is on the effect caused. Alright. Actus reus, always remember, will not happen barely because you do something. It is upon the actual outcome. Even if gun firing is an offense under Arms Act, if you shoot a gun but it does not have any bullets, if there is no ammunition, then it might not amount to an offense. So it's always the effect that is considered culpable. Before we come to mens rea, we need to discuss the effect of causation. Okay, that there always needs to be a causal link between the human conduct and the result, that is guilty. So there should always be a link between the harm and the conduct of the human. So there are different degrees of causal links. Okay, how proximate is the causation? The most important one is called causa causans, they are Latin terms, which is direct cause. This is the standard that we have to follow when we come to criminal law. The other one is called causa sine qua non, which is proximate cause, that this is a near cause. Alright, this is not the standard for criminal law. This is the standard normally in tort law, that whenever something is sufficiently the cause of a harm, then that will be considered a causa sine qua non, and that will not lead to criminal liability normally. Okay. The third one is remote cause. Okay. The cause cannot be too remote. Let's say you shoot someone in the leg and 3 weeks later they die. So the effect caused cannot be death. You cannot be blamed for causing the death of someone, okay, just because you shot them 3 weeks ago. Because you intended to shoot them, you shot them in the leg, so the effect caused will be of grievous hurt, but not of any form of murder or culpable homicide, right? In Rivaram versus State of Madhya Pradesh, the husband stabbed his wife multiple times. She died when she was brought to the hospital because of oxygen failure. Okay, oxygen failure cannot happen until unless a person has multiple punctures in their lung area. So it was held that this is clearly a case of direct causation. This is not any proximate cause. Okay. If you also look at section 299 explanation 2, okay, this is the explanation in for culpable homicide under the Bharatiya Nyaya Sanhita. This is section 100. Okay, section 299 explanation 2 says that even if through the intervention of doctors, timely intervention could have saved the person, but that does not happen because of any medical error, etc. That does not mean that the uh, criminal accused will be allowed any form of exception. They will still be liable for culpable homicide if they are the direct cause of death. Okay. Now there are multiple cases which lead to the development of direct cause jurisprudence in United Kingdom and USA. None of these are extremely important. If you're able to remember one of them, mostly from the UK side, it will be very good. Otherwise, none of these are landmark cases. Okay? These are in some way very important cases for UK, but until unless a question comes on this, these are not very important. The first one is R versus Roberts. Here, a man was driving with a woman, and the man threatened to assault the woman and to rape the woman. He jumped out of the car apprehending some form of sexual assault, and he got hurt. So now the question was, is the man liable for her jumping out of the car because she jumped out of her own will? But the court said, if you create the conditions in which someone has to jump, then you will not be responsible for you will be responsible for the jumping. So therefore, he was held guilty. Similarly, in R versus Blue, the person shot the victim. The victim had to receive a blood transfusion, but because of religious beliefs, the victim refused the blood transfusion. Now, the accused argued that the victim would have survived had they received the blood transfusion. It is not my fault that the victim has rejected any kind of blood transfusion. The court said no. When you stab the victim, when you shoot a victim, afterwards, uh, you cannot decide what is rational for the victim to do. Okay, if they already belong to a system of belief where they could not have taken such a step, then you have to accept that, and accordingly the chain of causation will not be broken. So this person was also held to be guilty. Okay, in R versus Stone and Dobinson, these two people were supposed to take care of an elderly lady. Now, during that lady's sickness, they absolutely disregarded her. Okay, they took zero care of her medical condition. They did not provide her either food or supplies. The lady could not do anything on her own. So these were the designated caretakers of that lady, and she died. So these people were held guilty because of reckless disregard. That this was a person under your care and protection. You were legally bound to care for them, and even then you did not care for them. So because of that, you will be guilty that you are directly the cause of this person's death. Now, similarly, a case happened in USA called People versus Beardsley. So this person's girlfriend they went to a room together where they were alone, but the woman took morphine. It is a narcotic drug, and took a high quantity of morphine and then died. So this person was tried that you were supposed to take care of your lover. how can you simply leave them to do what they have to? Okay, but it was held that both of them were intoxicated. He was not, both of them were responsible people. He was not in special position to take care of her. So therefore, he was not guilty because he was not responsible. Right? So all of these were cases of causation. In People versus Beardsley, it was held that just because someone is with you and doing something to harm themselves does not make you legally liable to protect anyone from injuring themselves. Okay. There is something called the doctrine of ordinary hazard. So, for example, let's say I am chasing someone with a stick. कि मैं डंडा लेके उसके पीछे भाग रहा हूँ कि मैं तेरा सर फोड़ दूंगा, ऐसा कुछ भी. तो and that person is running, and while they are running they stop there to see मैं कितना पीछे हूँ etc. And in that time lightning strikes them and they get injured or they die. Is it my fault? Because they could only reach that point जहाँ पे lightning हो रही थी because of me कि मैं पीछे डंडा लेके भाग रहा था. So this is called the doctrine of ordinary hazard, that creating circumstances such as geographical location is not enough. Okay? Will not be sufficient to establish that I am the direct cause for that person's harm. Right? Because this was an ordinary hazard. Anyone could have been ill-fortunate to be hit by lightning. It is not very specially because of the conduct of an accused person that they were brought in that condition. So therefore, such cases will not be considered as direct cause. Okay. Now we come to the next point called concurrence. Okay. Actus reus and mens rea both need to be at the same time. Let's say, in fact, this is actually a very famous case called Palani Swami Gondan. Emperor versus Palani's son. In this case, the accused person beat his wife. Okay, he beat her a lot that she got unconscious. So he thought that she had died. Now what to do? Because she had died, he had the intention to kill her, but she did not die at that time. So to hide all the evidence, he took her to a nearby tree and hung her body from the tree to show that she had committed suicide. Okay. Now at that time, the intention was not to cause the death because he thought she was already dead. In this case, the court acquitted the person. They said that this person cannot be liable for murder because when the death happened, his intention was not to cause death, and when the injury happened, the death had not happened. Okay, so he beat her, he thought she had died, he had the intention to kill, but he could not kill. And then later on, when he hung her from the tree, he did not have the intention to kill, but she ended up dying. So the court acquitted. They said that actus reus and mens rea did not exist at the same time, so this person cannot be guilty of murder. They will be guilty of grievous hurt, right, for causing bad injury. Now this was in the 1890s, Afterwards, the Privy Council, in this case of Thabo Mbeki versus Queen, this is a South African case wherein a person in very similar circumstances beat up a person, thought that they were dead, and to hide the body threw the person's body out in the cold, and where they died. So a similar argument was raised as Parani Swami Gondan case, that listen, when the death was caused, there was no intention to kill, and when there was an intention to kill, only an injury was caused, death was not caused. The court in this case said all of this is a complex single transaction. Okay, that you can't say that one act is separate from the other, all of them will be looked at together. Similarly, in R versus Lebrun in 1991, similar cases happened where a person hit the wife, where she got unconscious, and then later on tried to remove her unconscious body, and where she hit some rock and she died. So similar arguments were raised, and similarly a conviction was placed, because all of this is a complex single transaction. That series of acts and events will not be looked at in isolation but together to form the overall picture. The court will form the overall picture. I am telling you all of these cases, all of these are not important. Okay? Remember these if you can remember, but if you have a shortage of time, these are not the more landmark cases that we will be discussing. Okay? But always remember the section numbers which I tell you. Section numbers are important. For example, section 32 of the IPC says that an act includes omissions and series of acts and omissions. Okay, so multiple acts and omissions done will be counted as one single act for the purpose of what constitutes an offense. Okay, so you can't take the excuse that मैंने ये नहीं किया था या ये बाद में किया, etc. For example, in this case of Om Prakash versus State, this person beat up his wife. This was an act, and then denied food to the wife. This was an omission. The wife did not die, but this person was held guilty of section 307, attempt to murder, because the intention was clear that this was leading to a murder only. Okay. Consider this case partly landmark. Try to remember this. Okay, I will put 1 star near small landmark cases, 2 stars near large landmark cases. Also a good case, State of Kerala versus Govinda Swamy, 2016. This is the Soumya murder case. I don't know if you have heard of it. Back then it was quite a sensation. Okay, in this case, inside a train, in a moving train, passenger, a male passenger, boarded the ladies' coach where there was only one girl present, and he started beating her up with the intention of sexual assault. So the girl ended up jumping from the train. The man also jumped from the train and then raped him, after which she died. So the post-mortem report said that the primary injury which led to her death was because of jumping from the train tracks. All other injuries were not as grave. So the Supreme Court, while they convicted him for rape as well as robbery, but they did not convict the accused for murder. Okay. So this was highly criticized because if you look at the entire line of direct causation cases that we just discussed, the girl would have jumped only because of this persistent threat. She would not have jumped otherwise if there was no threat available. But in this case, the Supreme Court held that we will not be considering that a direct cause. It also went to review because it is called the Indri blocks. The Supreme Court took suo motu cognizance because Justice Markandeya Katju, a retired judge of the Supreme Court, he wrote a very sensational Facebook post about how there was gross miscarriage of justice in this particular case. The Supreme Court took specific cognizance that it is possible that miscarriage of justice might have happened. They asked Justice Katju, can you help us redecide this case? Everyone made their submissions. Multiple senior advocates also made their submissions. But ultimately, the court did not change their decision. They said that the decision is very sound. So this still remains a very highly criticized case. State of Kerala versus Govinda Swamy of 2016. Okay, this was Justice Ranjan Gogoi's judgment. Now we come to mens rea. This directly translates to mind. There is a very famous Latin maxim called actus non facitrium nisi mens citria. Okay. It says that the act cannot be guilty where the mind is not guilty. So you will see when we come to general exceptions the coming class that wherever the person did an act with an innocent intention, okay, where they were either acting in self-defense or they were not capable of forming the right kind of intention to commit an offense. For example, it could be a child, it could be a person of unsound mind. So if any of these cases exist, then there is no crime. All right, which is because the mind is not guilty. You don't want to punish someone if they never intended to commit a crime, because that does not help the society. Okay, you are punishing a crime because of certain social interests being violated, and we will discuss this more when we come to theories of punishment in the later part of this class. But that is why you don't want to punish someone who does not intend a particular offense. But normally intention is very difficult to prove. Okay, what was the accused person thinking when they committed the crime is something that only the accused person can very effectively tell you, and they will never say in a court of law that I actually intended to kill this person, I actually intended to kidnap or steal anything. तो आप तो किसी से भी पूछो कि भाई तुमने चोरी किया था क्या, वो बोलेगा मेरे को थोड़ी पता था. So all of this happens, and that is why you have to look at the surrounding circumstance. For example, normally courts look at the previous relationship of the accused with the victim. Were they in close contact, were they enemies, etc. You look at hostility between the parties. Did they have a history of threatening each other? Sometimes you see that neighbors have a disputed land and they keep telling each other कि तुम यहाँ आए तो मैं मतलब तुम्हें मार डालूंगा. Sometimes they have already had fought between each other multiple times. you look at that history, you look at any kind of instigation, was there any cause while they would have wanted any kind of revenge? Were they enraged by something? Were they provoked by something? Was there money involved? Okay, it could be a contract killer. So all of that you have to look at specific. Then you look at the chance of gain. Were they about to gain something directly? Okay. Was there insurance policy hoti hai kai baar? You tend to gain an insurance policy. Sometimes you have a lot of inheritance coming your way and you decide to eliminate your competition. So all of this has to be looked at to see what was the actual intention. Okay, because otherwise making a realistic portrait of the intention is very, very difficult. So there are multiple degrees of culpability which can constitute mens rea, right, depending upon the offense. You see, sometimes you need to intend something. There needs to be an intention where you actually willingly want a result. Sometimes there needs to be knowledge only. Sometimes it is just recklessness, that it is absolute disregard of any consequence. Okay, without wanting something. Let's say in rash driving cases, people are driving very fast on a road. They don't actively want to kill someone, but they are so careless, they are so indifferent to the outcome that they just want to carry on driving in a high speed, that they don't really care what happens. That is called recklessness. Then we come to negligence, that when you have a duty of care and you are unable to fulfill that duty of care and that causes harm to someone, and you were so negligent, you were so disregardful of your entire duty that the person suffers harm at a criminal level, that is called negligence. Okay, negligence of a criminal level. So these are different degrees of culpability. Motive as a whole is not necessary when we come to mens rea. Okay, the person might be doing something out of anger, out of revenge, out of greed, or any other emotion, but motive is not directly for mens rea. It is capable for establishing evidence that there was mens rea. Okay, but motive itself is different from mens rea. It comes before mens rea. All right. Professor Main, this is Professor John Dawson Main, who wrote this book called Hindu Law, which was one of the finest commentaries on Indian Penal Code in the early 20th century. So he wrote that the concept of mens rea is absolutely completely irrelevant for the offense of IPC, for offences mentioned in IPC. Why? Because there are different categories. Whoever dishonestly does something, for example, section 378, theft, you have to dishonestly move property. Okay, someone has to voluntarily cause harm. Okay. Is 319 hurt. Someone needs to have reason to believe. Okay, all of these, the very specific categories besides intention, knowledge, etc. Every single category of degree of culpability specifically mentioned within the statute itself. So whoever has reason to believe, this is for example when it comes to offences of stolen property, that if you are receiving stolen property, section 411, we'll see, if you have reason to believe that this is stolen property, then you cannot do anything. You have to you will be guilty if you still end up receiving that property. So all of these were established forms of mens rea. Many times you have to presume some kind of mens rea. Okay, even though it is clear in certain cases that mens rea was not there, you presume it for the purpose of benefit of the law. Okay, the first one is called transferred malice. Transferred malice happens when you are when you end up harming one individual instead of the intended target. Okay, let's say I am shooting and instead of shooting Ram, I shoot Sham. So even though I wanted to kill Ram, I had intention to kill Ram. I did not want to kill Sham. I had no intention to kill Sham, but that does not mean I will not be guilty of murder. Okay, section 301 IPC records this doctrine of transferred malice, that if you end up harming one individual, instead of if you cause the death of another individual other than the intended target, then also the same kind of intention will be applied upon you. That is 301 IPC. This is called the doctrine of transferred malice. Then we come to constructive malice, where if there is any foreseeable offense which is committed in the course of a different offense, then you will be responsible for all the offenses which are simultaneously committed. For example, section 395 in dacoity, if any other offense is committed, any other offense, okay, let's say a band of dacoits go to a village to raid and one of the dacoits ended up committing rape as well, then if that was foreseeable that all of these people went with that prospect, a different offense is committed, they will all be liable for the different offense as well. Okay, that is called constructive malice. The third kind is called conspiracy, where multiple persons, they may be a part of a larger plan to commit an offense. Okay, section 120A and 120B of these have punishments for conspiracy. Now, even if one person did not have a complete idea of what was going on, okay, they will still be responsible for the offense of conspiracy. Okay, so this does not really have a special term, it's just called conspiracy. So where you presume that all of them were a part of the conspiracy. Let's say it's a hub and spoke conspiracy, that this is A, he says that B will procure the guns, C will transport the guns, D will take the gun and give it to someone else, E will commit murder and F will commit robbery. Okay, so as long as all of them knew that there is a conspiracy, they don't know who is doing what or what exactly is to happen, they will all still be a part of the conspiracy and be punished for conspiracy. Now we come to statutory offences. This is where Professor John Dawson Main's specific criticism or declaration that entire mens rea doctrine is irrelevant for IPC comes to question, because there are many special offences which do not have mens rea. Okay, for example, state compliance, tax laws, or Foreign Exchange Management Act, all of these laws exclude mens rea. If you fail to pay tax, it's your liability even if you never intended this failure. Okay. If you cause any kind of public health hazard, okay, you end up adulterating food, selling adulterated food, or let's say you fail to pay minimum wage to your workers, you may not actively intend to cause any kind of forced labor. but that is the consequence of not paying minimum wages. So their intention is not looked at. The idea is people have to be cautious. Okay. So the Halsbury's laws of England, they have this quote that absence of any specific mention of a state of mind as an ingredient of an offence in a statute is not decisive of the question whether mens rea is an ingredient of the offence or not. Okay, this has been the general position that if a statute does not mention what degree of mens rea is required, that does not mean that no mens rea is required. Okay, that it is not an automatic exclusion of mens rea. So we will see what kind of statutory exclusion of mens rea has existed. First we will see the development in UK, because when we come to Indian law, a lot of it was shaped by UK law. Okay. Even now, all of this is not absolutely important. Okay. Read it if you're at your later stages of revision, but otherwise, just know the concepts. First one is R versus Prince. Always remember, whenever I say R, it means either Rex, which is king, or Regina, which is queen. Okay. Because in UK, the crown is supposed to be the punishing authority, the prosecuting authority. So R versus Prince, 1875. In this case, a man eloped with a woman thinking that she was 18 years old. She said she was 18 years old when in fact she was just 16. So he said that I had no mens rea, I thought she was 18. But the court said, listen, there is no scope of your belief. She was 16 and we just have to follow the law. So you are guilty. There is no mens rea because there is no mention of mens rea. Similarly, in R versus Tolson, there was a woman whose husband went missing. Okay, so for 1 year she tried for all possible routes. She sent letters, filed a police complaint, tried to contact any sort of friends, family, etc., etc. But when she could not find her husband, she remarried, thinking that the husband is now dead. So the court said you cannot presume that the husband is dead at least for 7 years. That's a 7-year rule. So you could not have presumed that they were dead for 7 years at least. So therefore, you are guilty of bigamy, of marrying twice, because that's a prohibition in law. All of this changed in this case of Cheras versus D. Rutson. Okay, there was a law which said in England only that you cannot serve alcohol to a constable who is on duty. Alright. So there was one constable who was on duty, but he was not in uniform. So the pub owner did not know that this is a constable on duty, police constable on duty. So they served alcohol. He was charged. It was argued that listen, there is no scope of mens rea in this, because the statute does not mention any kind of mens rea. If you serve alcohol to a cop, the cop is on duty, then you're simply guilty. The court said no, you have to incorporate mens rea. Alright. So mens rea was included in the statute, and the person, the pub owner, was held not guilty because they did not have any guilty intention. They did not have the intention to serve alcohol. Alright. Similarly, in Friend versus Wood, this is now 1946. In this case, Sharas versus D. Rudson was upheld, and Lord Goddard, the Chief Justice then, he gave this particular rule. Rule becomes the foundation. This is a considerably landmark case. Okay. Actually, let's put 2 stars here. That mens rea is applicable to statutory offences as well. Okay, even when the statute is silent, unless it is excluded by necessary implication or by express provision. Okay, that unless it is absolutely clear that mens rea is not meant to be a part of the statute, you cannot exclude rea merely because it's a statutory crime which does not mention mens rea. Right? So this was Lord Goddard CJ's rule. Now we come to Indian law. There were cases before this as well, but this is the most landmark case. Okay. State of Maharashtra versus Mayor Hans George, M.H. George, 1964. In this case, this German national brought 34 kgs of gold into India in his jacket, hidden in his jacket. His jacket had certain compartments which had blocks of gold in it, and there was an RBI notification which said that whenever you are bringing in gold into India, he was not traveling to India, he was traveling to Delhi to fly to Philippines. It was just a transit flight. The RBI notification said that if you're traveling to India, even through a transit flight, you need to declare that gold. Alright. Now the RBI notification was published 2 days before the flight of this person. So this person did not have any actual means to know whether or not he had to declare it. So then this person was arrested by customs authorities for having gold in his jacket. The majority held that the question basically which arose was, should mens rea be part of this? Because this person clearly did not even know about the law and was at a situation where he could not have known about this law. So is it right to punish them if they did not know? So the majority said it's a 3-judge case. Okay. The majority said that mens rea can be excluded by necessary implication or express provision. If mens rea has to be read into the statute, the degree of mens rea will depend upon the object of the law. So in this case, you have to see that RBI required people to declare their gold, and non-declaration itself is criminal. You cannot expect people to intentionally hide the gold. That will be a very strenuous exercise, and therefore they are guilty according to them. In his dissenting opinion, Justice Subba Rao said that it is very unnecessary, even if mens rea is read into the statute, that people should be punished only if they hide gold from the RBI. Even then, the criminal statute will not be rendered void. Okay? It will not be rendered meaningless. So therefore, it should not be unnecessarily excluded. And he said that for that reason, this person is not guilty. Nobody, very surprisingly, none of the benches went into this discussion that he was carrying gold in his jacket in a very clandestine manner, that he was a gold smuggler. So all of that is not taken into account in this case. It's basically a question of whether he could have had mens rea because he did not know about the law. Ultimately, the majority held him guilty. So no change in the actual question. The next case is Nathulal versus State of MP. This is also a landmark case. Okay, in this case, the food grains license was applied for by a person. Okay, this food grain trader, he was not communicated that his license was rejected. So his application was rejected, but because he did not know that his license application was rejected, he thought accept हो गया होगा, क्या ही फर्क पड़ता है. So he started storing food grains above the normal capacity, and so he was arrested. Now the court said in this case you have to read mens rea into the statute and person is not guilty. Okay. So in Nathulal, they read the case of State of Maharashtra versus M.H. George. In the case of State of Maharashtra versus M.H. George, they read Sharas versus D. Redson and Brent versus Wood. Okay. Sharas versus D. Redson and Brent versus Wood were specifically discussed in State of Maharashtra versus M.H. George. State of Maharashtra versus M.H. George was discussed in Nathulal versus State of Madhya Pradesh. Okay. Another very important case, landmark case, although this will be useful otherwise as well, Ranjit Odeshi versus State of Maharashtra, which said that in the offence of section 292 of obscenity, spreading obscene material does not require mens rea about the obscenity, about the obscene contents of the material. So if you are selling or distributing books with obscenity, you don't have to have that mens rea that I want to spread obscene materials. Okay. So the intention does not have to be to spread obscenity. You just need to have the act that you were spreading the materials, and the government will decide whether it was obscene or not. Alright, that was statutory exclusion in India. The last portion is vicarious liability. It is basically that someone else can be held responsible criminally for the wrongs of their employees or masters. Okay. Normally this is very common in tort law. We will actually have a class on vicarious liability in tort law, but for criminal law this is a very limited topic. In Emperor versus Hanumantappa, there was a gun manufacturer whose servant took certain materials home to manufacture the ammunition, and there was an explosion. So the manufacturer was also held liable, even though the explosion was caused by the servant, because it was his responsibility to ensure that all of it keeps within the confines of the factory. In an opposite case, in Sarju Prasad versus State, okay, the servant was selling adulterated food prepared by the master. Okay, so the servant was also held liable, although the servant did not cause the adulteration. He was only selling. The master had caused the adulteration. But even then, the servant was also held vicariously liable for selling adulterated food. Alright, so with this, we finish the topic of mens rea and general principles of crime. Right. Now we come to the second topic, punishments. Section 53 of the IPC prescribes punishments. Okay, there are basically 6 types of punishments that we see. First one is called death, punishment of death. It is also called capital punishment. The second one is imprisonment of life. The third one is imprisonment. This can be of 2 types: simple, where you are just imprisoned, and rigorous, where you are meant to do hard labor. Okay. The fourth one is forfeiture of property, where your assets can be taken over by the state. The fifth one is fine. Okay, आपके ऊपर चालान लगता है, जुर्माना भरना पड़ता है. In the previous Indian Penal Code, there was this one punishment called transportation, where you would be sent to that cellular jail in Andaman, Kala Pani, जिसको कहते थे. So now this has been deleted. Transportation and transportation for life is no longer an offence. This was a very colonial idea that we will put all criminals to a different place altogether. Once upon a time, very interestingly, Australia was the criminal colony of England, that they would send all of their criminals to Australia, but very soon Australia became a nation of its own. Anyway, so this was in section 53 of the IPC. In the new Bharatiya Nyaya Sanhita, there is a new punishment which is added called community service. Okay. Section 4 of the BNS corresponds to section 53 of IPC. Okay. Please keep noting wherever I mention that there is a corresponding section in the Bharatiya Nyaya Sanhita. It will always be beneficial whenever you write answers, that towards the end of it, if you are able to mention the specific section number of the Bharatiya Nyaya Sanhita, that will be helpful. That might fetch you half a mark more, and 3-4 times if you get half a mark more in this very section itself, that is 2-3 marks in part A, and that's just a good score, a good addition for very little information that you're adding. Now we come to the main part, the main crux of the harshest of all penalties, that is death penalty, a capital punishment. In India, it is offered for 7 cases as per the IPC. Waging war against India, section 127, 121. Abatement of mutiny, 132. Okay. Perjury, causing a death of an innocent person. Perjury is giving false evidence in court. So that is a punishable offence under 194 in itself. For murder, the section 302. Abetment of suicide of a minor or an insane person or an intoxicated person under section 305. Attempt to murder by someone who is already a life convict, someone who is convicted to life imprisonment if hurt is caused. Okay. Let's say Babulal is a convicted murderer. He is already serving life imprisonment in court for previous murder or murders that he has caused. Now in prison he might form a enmity with someone. He tries to stab them, and let's say that person has a cut on his hand or anything, but for this attempt to murder, death penalty can be prescribed. Dacoity with murder, okay, section 396, and certain aggravated rape provisions, okay, 376A, AB, DB, E, depending if it's rape of someone under the age of 12 or repeat offenders of rape, etc. For those offences also, death penalty is prescribed. The Bharatiya Nyaya Sanhita takes all of these, but simultaneously also adds mob lynching, where death is caused by one against a person, of a person, because of their caste, religion, race, etc. That is section 103 clause 2 is mob lynching. There are multiple other provisions where mob violence is considered for religious communal cases. Second one is terrorist act, section 113. If a terrorist act is caused which leads to death of any person, then death penalty can also be prescribed. Now let's come to the constitutionality of capital punishment. The primary case is Bachchan Singh. Okay. Capital punishment is normally considered very grave because it's state sponsored killing, that you are killing your own citizens for being a part of society, and that is normally considered, especially in many European human rights jurisprudence, that is considered very severe and inhuman in some way. So this was considered in the case of Bachchan Singh, and was under the CRPC. They have the Sessions Court has unguided discretion. That they could prescribe death penalty to any person where the offense says life imprisonment or death. So they could do it, that was completely upon them. So that was considered by the case of Bachchan Singh versus State of Punjab in 1980. Should this be allowed? So they said death penalty as a concept, as a punishment, is constitutionally valid, but it should only be awarded in the rarest of rare cases. Okay. So what is rarest of rare? You need to any judge needs to record special reasons for awarding a sentence of death. All right, and simultaneously mitigating circumstances have to be looked at. That you have to see whether or not there is a possibility of reform in this person, the age of the accused, the mental condition. These were some mitigating circumstances that should be looked at, but normally by the courts. So this ultimately came to be known as the rarest of rare doctrine. Right? In Mittu versus State of Punjab, the Supreme Court also said you cannot have mandatory death penalty. All right. Earlier, Section 303 of the IPC said that anyone who is already a life imprisonment convict, if they commit murder, then they will be given death only. There was only one punishment prescribed, death. The court said no, you cannot have mandatory death penalty. You need to have this can only be a discretionary punishment. It will be guided by the rarest of rare doctrine, but no mandatory death penalty is possible. Right? So after the courts have confirmed the death penalty, normally that yeah. Write it. Section 366 of CRPC, not IPC, says that if a sessions court awards a death sentence to anyone, that person will not be executed until unless the High Court has confirmed that death sentence. Okay, so the High Court has the primary responsibility after a sessions court has awarded death to confirm the sentence of death. After that begins the process of clemency. Okay, we saw clemency in the constitutional law lectures, that it is a discretionary power of the president or the governor that they exercise at the aid and advice the Council of Ministers. Article 72 provides the president with pardoning power the president alone can pardon a death sentence. They can say कि आज से तुम आजाद हो, तुम पूरी तरह free हो. The president also is the only authority to pardon any form of armed forces cases, because president is the supreme commander of armed force. Then we come to article 161, which is the corresponding provision for governor. Okay, so the governor cannot pardon a death sentence, but they can commute a death sentence to life imprisonment or less. Okay. So commutation means changing the form of sentence. You can change rigorous to simple imprisonment, etc., etc. Okay. So in this case of Maruram versus Union of India, the Supreme Court said that there can be no statutory fetters on the exercise of constitutional pardoning powers of the president and the governors. Section 433A of CRPC provides for a statutory guideline that for life imprisonment convicts, once they have served 14 years, the state government can look at their conduct and grant them pardon. Okay, can lead to their release, but that is for the state government. The Supreme Court said that yes, this is also a power that simultaneously exists, but the constitutional pardoning power of the president and the governor cannot be subjected to section 433A of CRPC. That remains a separate power in itself. Okay, that remains a constitutional power, and any statutory restriction will be void. So after a confirmation of death sentence by the High Court, at least, the clemency petition goes to a mercy petition goes to the president. So till 1970s, the time taken for mercy petitions was very less. It would happen very quickly, and within normally 10 to 15 days, maximum time was 11 months. Okay. But after 1980s, firstly, what happened? Bachchan Singh case came. The rarest of rare doctrine came. Secondly, there was a lot more political instability. It was not a politically strong era, the 1980s. So delays started happening. Okay. Average time increased to multiple years. Okay, average time increased 4 years on average. The case of Devinder Pal Singh Bullar, he was a person convicted in a Khalistani terror blast. The court said that delay in the execution gives no right of commutation. So, person was convicted in the 90s and then continued to stay in prison for multiple years. So after staying in prison and being a death row prisoner in prison is very, very mentally taxing for the prisoners of death row, because they go through a lot of weirdness that you can die any day. The court said yes, that's an issue, but that does not give you a right of commutation. Later, in cases of Triveni Bain and Vatheeswaram, the Supreme Court reiterated the need for expediting mercy in the 1990s. In 2000s, delay increased again. Okay. Now 7-8 years would pass and the mercy petition would not be heard. So ultimately in 2014, this is a very major case. Okay, Shatrughan Chauhan. The Supreme Court said ultimately that any inordinate delay that leads to can lead to torture. Okay, a delay in execution of death penalty, it's torture which violates Article 21, and this will automatically lead to commutation. Not automatically, but this will lead to commutation. So once delay is proved that there was inordinate delay, unnecessary delay, then the prisoner will be commuted. As of now, the Supreme Court in the same Shatrughan Chauhan case said there will be no distinction between terror cases and heinous crime cases. So this same Khalistani terrorist Devinder Pal Singh Bhullar, he was also released, commuted in 2014 because of the Shatrughan Chauhan case. In this entire process, in this set of cases, all of the cases which I have taught are important. Okay, Shatrughan Chauhan is very, very important, but Triveni Bain, Vatiswaram, Devinder Pal Singh Bhullar, all of these are also important. Maru Ram is extremely important because it's about the constitutional powers of mercy. Bachchan Singh and Mithu are also extremely important. Okay, so 1, 2, 3 and 4. These 4 are extremely important, and then 3 other cases of minor importance. Okay. Now we come to the question of death penalty's abolition. There is an entire school of reform called the abolitionists who don't want death penalty to exist. Right? So there was a death penalty report by Project 39A of NLU Delhi. It is run by Professor Anup Surendranath. The Project 39A, we'll see, 39A stands for Article 39A, which is the right to legal aid under directive principles. So this project seeks to provide legal aid to different sections of society, and it constitutes one of the most in-depth research on death row and death row prisoners. So they produce annual statistics whenever you're writing your mains, be it 2025, 2026, etc. Keep checking the annual statistics published by Project 39A. As of now, there are 561 prisoners, of whom on the death penalty system, of which 488 are awaiting High Court confirmation under Section 366 CRPC. Okay, we saw that Section 366 CRPC is mandatory, without which death penalty cannot be executed. So this is the only place where all of these statistics are compiled. The Law Commission of India has also, in its 262nd report, they have suggested phased abolition. That you should gradually abolish death penalty from all cases except terrorism. That keep it for terrorist cases, but for other cases don't have death penalty. The penalty of life imprisonment is enough. Okay, the general argument of the abolitionists is that severity of punishment is not as important as certainty of punishment to stop crime. We will discuss this when it comes to the theories of punishment after this. Okay. So here the Law Commission supported phased abolition. In Channulal Verma versus Union of India 2018, the court said it is now time to review the constitutionality of death penalty again. Basically, that 40 years have passed since Bachchan Singh. So now that same case can be reviewed again with fresh evidence. Earlier it was more a matter of debate and principles, etc. Now with a lot of research has happened on death penalty in India as well as across the world. So now that can be reviewed. In Manoj versus State of Madhya Pradesh 2022, the Supreme Court, this is also a very landmark case, Manoj. The Supreme Court said that you need to have practical guidelines for the trial courts, that at the trial stage itself there needs to be an opportunity to check the mental conditions and mitigating circumstances of the accused. If it happens at a later stage, that is no longer a good thing because they are already sentenced to death penalty. So trial courts have to see any material disclosing psychiatric or psychological evaluation of the accused. Okay, this has to be done if you are considering death penalty, or any information regarding the accused jail condition or behavior, work, etc. from the relevant jail authorities. They have to send a report, and all of this will be considered at the trial stage itself. This will not be a matter that high courts have to see or the Supreme Court has to see. Okay, because what happens is it takes many years for the High Court to confirm at times, or the Supreme Court to confirm after that, and that is also a form of delay. So the Supreme Court said that this has to happen at the trial stage itself. Now multiple statistics say that by project 39A itself, they have said that 40 plus cases have happened after the Manoj judgment where the guidelines were not followed. So that is another question of judicial accountability, which is not directly in our scope. Towards the in one of the final lectures, I will be discussing criminal justice system reforms. We can discuss it then. Okay. Now we come to theories of punishment. Okay. Why do we punish someone? So there are multiple views. Different criminologists have different views that X, Y, Z reasons exist. The first and foremost is the theory of retribution. Eye for an eye. If you have harmed someone, you deserve to be harmed, so that you realize how bad it is to harm someone. Right? Another view is that for retribution only, proportional retribution. That let's have let's at least ensure that some degree of harm is received to the criminal as well. The second is denunciatory theory, denunciation, where you say that crime is condemned. This is normally applicable for orthodox societies. For example, homosexuality as a crime. It does not really affect anyone. If two consenting adults are engaging in sexual intercourse in their private space, it is not really impacting someone. It is just horrifying the rest of the society that oh, ye kaise kar rahe hain. So you want to denounce a crime. Okay? Same goes for consumption of narcotic drugs. Let's say that if a society criminalizes consumption of narcotic drugs, a person who is taking a drug is doing harm to themselves. They are not harming anyone else. Selling of drugs is very different from consuming. So, but the society wants to punish them because crime is condemned. You just want to denounce a criminal for engaging in an action that the society did not want. You just want to punish that kind of criminal activity. The third theory is deterrence. Deterrence means to stop further crime. Okay, how do you ensure that you can stop further crime? First is general deterrence. You set an example. Okay, let's say someone commits theft. You arrest them in some countries you chop off their hands to set an example to the rest of the public कि अगर आपने चोरी किया तो आपके साथ ये सब किया जाएगा. So you do that, that sets a deterrent to the rest of the public कि सब डर जाएंगे. Okay, so the general public is deterred. The other theory is specific deterrence. That let's say someone is a habitual criminal. If you arrest them, you put them in jail, they will not commit offense. Okay? They will not commit offense again. तो जेल में है तो वो कैसे करेगा? So there are two theories of deterrence. The last one is called reformative theory. In this theory, the criminal is supposed to be a product of society, a misfit in society. So they are only committing crimes because they are deviating from established social norms. You take them to some kind of reformatory home, and there you teach them how to fit into the values of society. You teach them the values, how to practice those values, and then you release them into a society as a reformed individual. Okay, so that they are no longer deviant, but they are now a part of the society itself. So this is called the reformative theory. Now Supreme Court, in this case of Jaswinder Singh versus Navjot Singh Sidhu, Jaswinder Singh was a victim of an accident by Navjot Singh Sidhu. Okay, they said, the Supreme Court said that undue harshness is not needed in punishment. Okay? It need not be disproportionately high. But if a punishment is disproportionately low, if it is very light punishment, then that can also frustrate the victim and also later on harm the community, because that can reduce the faith in justice. Okay. So that is why the punishment has to be very proportionate. It cannot be very, very light, it cannot be very, very harsh. There is one important case Vishnav Deo 8, in which case Justice O. Chinnappa Reddy discusses the application of all of these theories of deterrence to the death penalty. Okay. So he says that retribution and denunciation theories fit death penalty. That under these theories, death penalty is fine. But even for retribution, not in all cases. Because in some cases, you are not causing the death of a person. So in those cases, you cannot be sentenced to death. Then he says deterrence does not fit. Retribution fits because अगर आपने किसी का मर्डर किया है तो स्टेट भी आपका मर्डर कर देगा. और but he says that the point of retribution was to show the person that how it feels to commit an act. If the person is dead, they will never be able to feel. Okay. He says deterrence, so he says retribution might or might not fit depending upon purpose of retribution. Denunciation fits completely because you condemn the crime that they have done. Deterrence does not fit the scope of death penalty because to set an example, the harshness of punishment is not enough. For so many years, we have had death penalty for so many cases, but the crimes still continue. People have not really stopped committing the crimes merely because there is death penalty. So this is a major issue, that there is no evidence that there is actual deterrence. Specific deterrence, obviously if you kill the person, they will never commit a crime again. But if you put the person in life imprisonment, then also they will not commit the crime again. Reformatory justice also does not fit. अब आपने मार ही दिया तो वो कहाँ से वापस रिफॉर्म होएगा कि the person will die. So this was the case of Krishna Dev versus state. Even the death penalty report of NLU Delhi, National Law University Delhi, they accept this principle that as of now there is no particular evidence that anyone has been stopped from committing a crime merely because उसके लिए death penalty. This is more of a rhetoric that whenever someone commits a very harsh crime, the society becomes very angry and they express their anger through harshness of punishment. So that is why you demand very harsh punishments, and when the crimes do not stop even after harsh punishments are imposed, then you seek to increase the harshness later on. For example, now because death penalty is not working, people are also in support of torture of the death row prisoners. Whoever rapes and kills a victim, they should also be tortured. But there are countries where rape and torture also happens, and they also have high rates of death penalty, high rates of rape despite that. So that is not really a solution. The solution may lie more in certainty of punishment. That if everyone agrees that this is a crime and everyone condemns that person, and simultaneously that they are sure that if they commit a crime, they will mandatorily get a punishment. Let's say life imprisonment, 20 years imprisonment, any punishment. If they are certain of getting it, that might be a greater deterrent. So that is one of the part of the theories, that evidence has to be looked at, and death penalty might not be a great penalty. Many European jurisdictions have abolished death penalty, and they refuse to send back people who have left from India or convicts of India or wanted accused from India. They refuse to send those people back to India because they say आप इनको मौत की सजा दे दोगे, and their justice system does not allow anyone to be killed by another country. So all of these things exist, and which is why the law commission, it said that it might be national interest as well that you keep them as imprisoned, life imprisonment convicts. Keep them that let there be no opportunity for parole as well, that mandatory life imprisonment कर दो. पर आप अगर death penalty करोगे, that creates international consequences as well, and that is in general not a very good message for society. So all of these arguments do exist as of now, and normally there are more arguments in favor of abolishing death penalty, although the general sentiment of the public favors death penalty, because the view is that it will still be a very good deterrent, that some people are actually stopped from committing crimes because of the harshness of penalty, and that it also feels better to the victim that the perpetrators of horrifying crimes are no longer present, that they are now dead. So all of these emotional arguments also exist. You can write both ways if there is ever a question, okay, on this, but it is important to know both sides of the argument. Okay. This topic 3. Attempt or preparation. So there are 4 stages of an offense. Okay. The first one is the stage of intention. For example, you just have a desire to poison X, मैं x को जहर दे देता हूँ, that is just an intention. Okay, this is never punishable. This is the same category as thought crime, कि कोई आपका मन नहीं पढ़ सकता. Second one is preparation, where for example you are buying poison, because आपको x को देना है poison. So in very limited circumstances, we will see in the next slide, preparation can be punishable, but it is rarely punished. Then comes attempt. For example, you mix poison in excess food. अब x ने खाया नहीं खाया आपके हाथ में नहीं है वो, है ना. This is normally always punishable. The ordinary course, this is punishable as attempt. Attempt to commit an offense is also an offense. The last is commission of an offense, okay, where x dies of poison. Because remember, the effect has to be caused for the offense to be complete. Actus reus is the effect cause, so x has to die. It's always punishable, right? So these are the 4 stages of the offense. An attempt is an inchoate offense. Okay, inchoate means something like an incomplete offense. That if it was complete, then it would have been a full offense. So it is a partial offense. No strict definition of attempt exists. Okay, attempt is not defined anywhere in the IPC, and in this case called Kopala Venkat Rao versus State of Andhra Pradesh, the Supreme Court said that you need to look at the ordinary dictionary definition, okay, of attempt. Right. Whenever multiple definitions basically give you a sense of what is an offense, that if something is set in the course of transmission of commission, but if it will succeed if not interrupted by an external source, then that will be the offense of then the attempt is complete even if the offense is not complete. Okay, so attempts and preparation are 2 different stages. Okay, it is very hard to distinguish, we will distinguish in the coming slide, but preparation is punished in very limited circumstances. For example, in section 122, when you're preparing for waging war against India, 126, preparing for waging war against India's allies, then section 399, when you're preparing for dacoity. All 3 of these are punishable as preparation. Okay, where preparation is punishable. क्या आपके पास ये सब भी मिल गया तो भी. Attempt is punishable differently for different offenses. Okay, sometimes there is the exact same punishment whether it is an attempt or the actual offense. For example, section 124A sedition, 153A inciting communal hatred. So whoever incites disaffection or attempts to incite disaffection, whoever tries to inflame communal sentiments, attempts to inflame communal sentiments and cause violence, they are also guilty of the same offense of actually inciting communal violence. Section 398, okay, dacoity. An attempt to commit dacoity is punished as the same way as a dacoity. कि आप अपना पूरा वो गब्बर सिंह और उसके वो डाकू अगर घोड़े लेके बंदूक से पहुंच गए and they are unable to commit the dacoity because उनको किसी ने रोक दिया, that is still punishable in the same way as the offense of dacoity. Okay, then we have attempt as a separate offense for many different offenses. For example, section 307, attempt to murder, is a very separate offense. It has different lesser punishment. Okay, section 393, attempt to robbery, that if your theft or extortion is incomplete, you will see, but that is also a separate offense. Okay, that is not punished as the same way as a robbery, but dacoity is punished as the same way as an attempt for dacoity. And then there are many cases where there is no punishment prescribed. So section 511 has a general clause that attempt to commit any offence punishable under IPC can be punishable under section 511 of IPC. All right. There are 5 major tests of what constitutes attempt. Each of these has one important case. All 5 of these are important. All 5 of these cases also. Okay. First one is proximity test. Okay, when you are very close to commission of the offence. State of Maharashtra versus Mohammad Yaqub. There was a smuggler who was bringing goods to smuggle to another country, and he had reached the port where he would put all the materials, etc. And he was about to reach the boat when the smuggler was caught, the boat was caught, etc. etc. So he said कि मैं तो कुछ किया ही नहीं अभी तक. I am just traveling with materials and there is just a boat elsewhere. So the court said no, you are very proximate to the entire cause. That this is not preparation, this is an attempt, because थोड़ी सी देर में तुम वो act ही commit कर देते, तो smuggling करनी शुरू कर देते. So when you are very close to commission, you can be booked for proximity test. Then comes locus ponitentia. Okay. Please note the spelling. It is basically locus, poem का poem, I10 TIAE. This spelling is weird, but it is basically a word that you use in contract law many times, locus ponitentia, where you say that you have the option to withdraw. Okay, whenever you have an option to withdraw, till that stage, it will be preparation only, it will not be an attempt. Right? So in State versus Malkiyat Singh, there was a paddy transporter. In the license Raj era, you needed licenses to transport paddy from one state to another. So there was a paddy transporter who was transporting from the Punjab border into Delhi once upon a time when Haryana was not a separate state. So they were apprehended, the truck was apprehended in Punjab itself. The court said that they had the option to withdraw, right? They could have, they were caught far away, many 40-50 kilometers away from the border. So they still had the chance of not committing the offense of going across the border. You have to see that, and accordingly, this option to withdraw will remain. That if as long as they have an option to withdraw, it will be preparation only, which is not a crime for this offense and not an attempt. After that, once the option to withdraw has ceased, then it will be an attempt. Okay. Let's say if they are on a one-way road, कि अब यहाँ से आप सीधा सिर्फ दिल्ली ही जा सकते हो, अब आप उसी पे चलना शुरू हो गए हो finally, there is no U-turn, nothing left, then you don't have an option to withdraw. In that case, it will not be preparation anymore, then it will be a full-fledged attempt. Okay. Equivocality test. You need to take some unequivocal step. Okay, very unambiguously, you need to show that there was an intention to commit the offense. Okay, for example, let's say you adulterate some food. आपने नमक में आटा डाल दिया या फिर कुछ और मिलाना शुरू कर दिया, so that you are able to sell higher quantities of it. Okay, but you still haven't sold, it's just lying in packets in your shop. So, but that shows your intention, that have an unequivocal intention of selling adulterated food. In Dambarudhar Injal versus State of Assam, there was an unequivocal intention of committing dacoity. Okay, and therefore they were arrested, they were punished for the offense of dacoity, because attempt to dacoity is punished in as dacoity. कि सारे आपने weapons ready कर लिए, आपने घोड़े ready कर लिए, सब कुछ, तो अब आप पकड़े गए हो, इसका ये मतलब नहीं है कि you can't say you had an option to withdraw. All right. Then we have the probable desistance test, that once an act is outside the control of the accused, it would be an offense if not interrupted later on. Okay, मतलब अगर let's say I shoot a bullet out of my gun and it misses the person, or let's say if I shoot an arrow and the person ducks, dodges, etc., उनको नहीं लगी, so that is outside my control. Okay, it would be an offense if it is not interrupted. In the case of Abhayanand Mishra versus State of Bihar, the person sent forged documents to get an admission into university, but the forgery was discovered and ultimately he could not get into university, but it was still an attempt at forging your admission, so therefore he was punished for attempt. Last is the impossibility test, that if you are attempting to commit an impossible crime, that is also an offense. Okay, for example, if you break open an empty jewel box, कि jewels रखे हुए हैं, आपको लग रहा है, अब आपने वो पूरा डब्बा उसकी पूरी तोड़ दिया, आपने देखा कि डब्बा तो खाली है, that is still an attempt, even though you could never have stolen jewels from that box, that is still possible. However, it is not a crime if it was impossible due to your own mistake. Right? Let's say you were mixing sugar instead of poison, right? कि आपको लग रहा है कि मैं तो इसके पानी में कोई बहुत ही मेजर ड्रिंक या कुछ मेजर पॉइजन मिला रहा हूँ, साइनाइड डाल रहा हूँ, बट एक्चुअली में आप चीनी डाल रहे हो, so that is not a crime because you're stupid. So own mistake is not a crime. The same happens if you're own superstitious as well. Okay, in case of Asghar Ali Pradhania versus Emperor, this person attempted to cause miscarriage of a woman by giving them certain plants, कि आप ये हल्दी खा लो, ये थोड़ा बहुत ये सब खा लो and miscarriage हो जाएगी. So he was charged कि this is attempt to cause miscarriage, but he never had the ability. Those were harmless herbs. He thought कि उससे हो जाएगा. He had the intention, but it is the same as mixing sugar in poison instead of poison. So your superstitions don't count, right? So these are also these 5 cases, and besides that, the Coppola Venkat Rao case. All of these are landmark cases. All 6 of these are important for the topic of attempt. Thank you.